Good evening, all of you. We welcome you to the third lecture of the SCAORA Academy in the e-lecture series. We have our beloved Arvind Datar sir today with us, who all of us know very well, and it is our privilege to have sir's august presence with us. Sir was always busy with IIM and Cambridge. With great difficulty, we got him to address us today. So we welcome you, sir. And on behalf of SCAORA, I request our Vice President, Mr. Manoj Mishra, to formally deliver the welcome speech.
Honorable Mr. Arvind Datar, Senior Advocate, Honorable Judges of the Honorable Supreme Court of India, and Honorable Judges of the High Courts, Mr. Shivaji M. Jadhav, President, Supreme Court Advocate and Accord Association, Dr. Joseph Aristotle, Honorary Secretary, Ms. Diksha Rai, Joint Secretary, Mr. Nikhil Jain, Treasurer, Mr. Atulesh Kumar, Joint Treasurer, Executive Members, Dr. Aman Hingorani, Ms. Anju Varke, Mr. Aljo Joseph, Mr. Sachin Sharma, Mr. Abhinav Ramakrishna, and Mr. Barinder Kumar Sharma. Supreme Court Bar Association Office Bearers, Mr. Vikas Singh, President, Mr. Pradeep Rai, Vice President, Mr. Ardend Mauli Kumar Prasad, Honorary Secretary, Mr. Rahul Kaushik, Joint Secretary, Mr. Minesh Kumar Dubey, Treasurer, Dr. Ritu Bharadwaj, Joint Treasurer, and other office bearers, and executive members of SCBA, and learned senior advocates, distinguished members of the bar, respected ladies and gentlemen. The SCAORA is organizing the present e-lecture series, and the first e-lecture was delivered by Mr. Harish Salve, Senior Advocate, on topic of basic structure analysis. And second e-lecture was delivered by Mr. Mukul Rohatgi, Senior Advocate, on topics of disqualification under the 10th schedule of the Constitution of India. We have reassembled today by virtual mode here for our third e-lecture theme, Tribunalisation in India, with emphasis on famous judgment of the Supreme Court in cases of L. Chandrakumar versus Union of India and others, Roger Matthew versus South Indian Bank Limited and others, and Madras Bar Association versus Union of India and others. It is great day for SCAORA for today's topic, as we could not found a better speaker than Mr. Arvind Datar, Senior Advocate. Mr. Datar is a prominent senior advocate of the Supreme Court of India. He has appeared before the Supreme Court in various landmark cases, including the Vodafone income tax case, National Tax Tribunal case, the SEBI Sahara case, and the NJAC appointment of judges case, as well as in other various famous cases. Mr. Datar specializes in tax, company, and constitutional matters, having authored several highly regarded legal commentaries, which includes Guide to Central Excise Law and Practice with Accounting Practices, Commentary on the Constitution of India, among others. He was revising editor of a Ramaiya Guide to the Companies Act, and Kanga and Palkhiwala's The Law and Practice of Income Tax. Mr. Datar is also known to be highly charitable and benevolent towards the lawyers community as well as the less privileged classes of society. I am sure that after listening the present lecture on our topic of the day, it will give you valuable thoughts and learning. I once again welcome all of you on behalf of SCAORA to participate and gain from it. Thank you.
Thank you, Manoj sir. We welcome you, sir. Now I request Diksha, Joint Secretary, to formally introduce Sir. Although Sir requires no introduction, you're more of a living legend amidst us, Sir. I request Diksha to formally introduce Sir.
Well, fortunately and unfortunately, both you and Mr. Mishra have taken all my lines. But Sir, of course, knowledge should be passed on. And Mr. Datar, who's a living legend for us, is a tax expert. He's written books, and I think he's on a mission to pass on knowledge, which is it's amazing for all of us here, because we see him in action in all these aspects. He's authored so many books. He's authored Guide to Central Excise Law and Practices, Guide to Central Excise Procedure, Tatar and Constitution, which is on its way for the 3rd edition. He's co-authored The Courtroom Geniuses. I wanted to ask him, what is the word for it? Ardent admirer, or as he said, indirect junior of Mr. Palkiwala. I think all lawyers need a flame in their life in terms of what they, the inspiration that they have in terms of the profession. And I believe that perhaps may have more than one flame, but yes, Mr. Palkiwala definitely served as one. And today's lecture series, let's take that mission forward. And without any further delay, Mr. Datar, to you.
Thank you. Actually, introduction is not necessary because we are all family and we know each other. It's unfortunate that for 2 years we have not been able to meet each other physically. And I hope that, in fact, I was told by some journalists that this is the last variant of COVID. And by March, there's going to be no COVID. So I hope his prediction comes true and we are rid of this constant fear of being closed and living in masks and testing positive and testing negative and so on and so forth. Well, let me start by thanking all of you for inviting me. I must thank Mr. Jadhav, the president of SCAORA, Sri Manoj Mishra for the very kind introduction, Dr. Aristotle for briefly introducing me and also for bearing with the delays, etc., that took place from time to time. Diksha, also, you've been so kind enough. I asked you adjournment, so to speak, once or twice for this lecture, and you readily granted it without imposing any costs. Thank you so much for that. I must thank the treasurer, Sri Nikhil Jain. All of you have taken the time to come on a Saturday afternoon and listen to this lecture. I can also see my friend Aman Ingorani there. When you mentioned courtroom genius, I had the privilege of speaking to his father and his mother as well. And I learned several facets of the Kesan Bharati case. And I was very pleasantly surprised to learn more about Nirande from Aman's father. So the topic for the day, I chose this topic on tribunalisation in India because it was a very live topic. Supreme Court has recently delivered an important decision in Roger Matthew. And I think that in 2022, at the beginning of the year, we are on what I call a fork in the road. We have to now decide what path we are going to choose as far as tribunals are concerned. What is our vision for the tribunal movement? When I joined the bar in 1980, we had basically judicial tribunals. We had, at least in the Madras High Court where I started my practice, we had the Motor Accidents Tribunal, which was the 5th small causes court. We had various rent control tribunals, which were the other small causes courts. We had the Industrial Tribunal, which was part of the district judiciary. So basically, these were judicial tribunals, tribunals controlled by the judiciary as part and parcel of the judiciary. On quasi-judicial tribunals, we had the Income Tax Appellate Tribunal, where I started my career. I did from 1980 to 81, I practiced on the civil side. And then I started practicing on income tax. And from 81 to 84, when I was a junior with a leading law firm in Chennai, I practiced in the Income Tax Appellate Tribunal. And they still remain one of my happiest days. We had such wonderful members of tribunals who were outstanding, who were completely judicial. They encouraged juniors. So it was a very nice time. So we also had the Sales Tax Tribunal, which was housed in the High Court campus. So basically, there were not many tribunals. There was Income Tax Tribunal and the Sales Tax Tribunal, and that's all. We didn't have NCLT, DRT, all these things were all in the distant future. And interestingly, one point I'll make as far as the Income Tax Appellate Tribunal is concerned, this tribunal started in 1941. In fact, it was started in 1941. And very important point I should note was to preserve the independence of the tribunal. The then colonial government put the Income Tax Tribunal under Ministry of Law and not under Ministry of Finance. And till today, the Tribunal of Income Tax Tribunal continues to function under the Ministry of Law. And it was very, very interesting. Many of the presidents of the tribunal became judges. Recently, we had the sad news of the passing away of Justice Ranganathan, who was a president of the Income Tax Appellate Tribunal. He joined the tribunal at a young age, rose to be president, then was Delhi High Court judge for 11 years, and then became a Supreme Court judge. But as a matter of justice of interest, the first president of the tribunal, Justice Munir Mohammed, migrated to Pakistan and became Chief Justice of the Pakistan Supreme Court. So this was the tradition of tribunals where you had very outstanding members and so on. Now, just going fast forward because time is short. In 1982, we had the Excise Tribunal. See, what happened was by then the excise and customs collections galloped, and the collection of indirect taxes became more than the collection of direct taxes. We had disputes on excise, on customs, and so on. So it was thought that let's have an Excise Tribunal, which was then called the Customs Excise Gold Control Appellate Tribunal, CGAT, which later became the Customs Excise Service Tax Appellate Tribunal. I think many members of the bar would have an occasion to practice in this tribunal. And it was patterned on the same thing of the Income Tax Tribunal. There is a judicial member, there is an accountant member, and there is a president and vice president. This started in 1982. And then in the 90s, we had a galloping increase of tribunals. We first had the Company Law Board, which was started in Delhi with some regional benches in Chennai, in Madras, Bombay, Calcutta. The major thrust to the tribunal movement really came with the DRT, and you had the famous Delhi Bar Association case where the provisions of the DRT were challenged. And if you see the Delhi High Court judgment of Justice Wadhwa, many provisions, he said, I'll strike it down. And when the matter came to Supreme Court, they kept on making amendments, and finally the DRT came into being. Now, to cut a long story short, one thing I missed here was that in 1986, we had the CAT and the SAT, Central Administrative Tribunal and various state administrative tribunals. Now, one point we should all note as the CAT and SAT are the only two constitutional tribunals in the sense that they have been formed under Article 323A of the Constitution. When the infamous, I would use the word infamous, 42nd Amendment was passed in the emergency where the powers of the Supreme Court, High Court, etc. were drastically reduced. They created tribunals. 323A was administrative tribunals and 323 was other tribunals. They could create tribunals on any subject, tax, everything. And the idea was, to the extent possible, replace the high courts. And these tribunals were given the powers to strike down laws, to do all these things. And as you know, they led to the Sampath Kumar case and Chandra Kumar case on tribunals. But you had the CAT and SAT, these were constitutional tribunals. So by the time we came to the turn of the century, the tribunals were fairly entrenched and they kept on increasing. Every year you would have some new subject. You had the intellectual property appellate board, patents and trademarks were shifted. Then in 2002, you had the company tribunal, and so on and so forth. I got into this tribunal thing. I started, the Madras Bar Association started opposing some parts of the tribunal system because we said that, look, if the tribunal is going to decide cases decided by the high courts, then the tribunals must be independent. They can't be manned by executives. They can't be manned only by retired civil servants and so on. And we said this is not on. Initially, when the Company Law Board came, we partly succeeded in the Madras High Court. And it was made clear that the chairman must be a retired judge. They should be a judicial member. And that was the thing of the Company Law Board. When the NCLT came, it replaced the company law all across the country. No high court would have any company law. Most of the cases were shifted to the National Company Law Tribunal. And it was a very worrisome thing, and our general body decided that we should challenge it in the High Court. Because the members could be completely from the bureaucracy. There was very little independence. The selection committee also was controlled. So in effect, it was a very, very unfortunate state of affairs at that point of time. What was also significant was that we in the Madras High Court referred to several decisions of different countries, the Privy Council, Canada, Australia, so on. And we tried to, in fact, I had argued in the Madras High Court and in the Supreme Court that there is no country in the world which has a company law tribunal. Because the general rule is tribunal should be there between where the litigation is between the citizen and the state. Income tax tribunal is income tax department with the state. SEBI is between the SEBI regulator and the person involved in the securities. You take excise tribunal, it's department and the citizen. But we should not have a situation where two private cases are referred to a tribunal. They should only go to the civil courts. Our stand was that if it's a company dispute, if it's a trademark dispute, if it's a patent dispute, it's a list between two individuals and it should not go the tribunals outside the judiciary. There is a very interesting UK Supreme Court case. All of us have studied separation of powers. We say executive, legislature, judiciary. And in Ram Jivaya Kapoor, we learned that there is no strict separation of powers, but there can be overlapping of powers. But the UK Supreme Court has now taken the view, the House of Lords, that while there can be overlapping between the legislature and the executive, there can be no overlapping as far as the judiciary is concerned. The judicial function should remain completely independent, free from any executive or legislative control. That is the important theory. So, unfortunately or fortunately, the NCLT was upheld, but the Supreme Court was right in laying down several important conditions where they tried to ensure the independence of the NCLT to the maximum extent possible. For example, they said that the term will be only 3 years. Supreme Court said no, it has to be minimum of 5 years. In Sampath Kumar, they said it takes 5 years for a member to get tuned and get expertise in that subject, so let it be 5 years. Other restrictions were imposed saying that the selection must be by a committee where the number of judges predominate. So, to the extent possible, Supreme Court imposed safeguards and NCLT started, and it's still continuing. The major change came in 2017, where suddenly in the finance bill, if my memory is right, it was not there in the original bill, it was added at the last minute. And 17 or 18 different tribunals, the acts were amended, and you had new tribunal rules where all tribunals had a term of 3 years. Members could be there only for 3 years. The selection committee was a case where the secretaries predominated and so on. That was challenged before the Supreme Court. From 2017, the matter went on, and finally, a bench of 5 judges in Roger Matthews' case settled the law and laid down important guidelines for the tribunal. Despite this decision, again the rules were amended. Again, we challenged it before the Supreme Court, and now the Madras Bar Association has, in the case of Madras Bar Association, Supreme Court has suggested that there should be a National Tribunals Commission. Now, according to me, my view is that tribunals are important. They have a very important place to play in the justice delivery system. In matters of tax, maybe service, maybe armed forces, if you create tribunals and you make sure that all the vacancies are filled, the infrastructure is given, there will be a huge amount of disposal of cases. Take, for example, the consumer courts. In many states, the consumer vacancies have not been filled up. You take DRT, the vacancies are not filled up. So one suggestion we made was, if there is a National Tribunals Commission, manned by, say, a permanent secretariat, they will keep a complete track of the vacancies, infrastructure requirements, appointments, postings, etc. And we need not trouble the Supreme Court judges with selection of these tribunals and again repeatedly coming to court with cases. A National Tribunals Commission, on the lines of what is prevailing in the UK, can be adopted in India. And I was told that in Singapore, they take law as an engine of economic growth. The 7th largest source of GDP in Singapore is law. So just imagine if you have enough courts under the Consumer Protection Act, enough tribunals under various acts. Please see the amount of disposal you will get, how much of burden will be reduced by the High Court, and most important for all of us, how much of work will be generated. And at least the citizen has a mechanism to go to a justice delivery system. Today, if a consumer has a dispute, there are hardly any consumer courts. No, nobody's there. But if all the consumer courts are manned as required by the Act, the cases are disposed of in 6 months or 9 months as mandated by the statute, maybe by a year and a half. At least today you have a hope that some relief will be given to the consumer. Today, if there is a relief today, as some people told me, suppose somebody doesn't pay me 2 lakhs of rupees, he cheats me. I have virtually no remedy because no point going to the consumer court or go to the forum, it is going to take a long time. So now, with this background, it is now clear that if the present system goes on, then we are not going to have an efficient tribunal system. At the same time, the need of the hour is an effective functioning tribunal system, which can be a very important partner with the judiciary in disposing cases, in delivering justice. What are the difficulties? Because we have been doing this, I started doing these tribunal cases in 1987. So now it's almost 34 years since we are fighting. The Madras Bar Association is fighting repeated battles on the tribunals, trying to make sure that they are as independent as possible. They get the maximum infrastructure as possible. For example, when the Intellectual Property Appellate Board was started, headquartered in Madras, it had an office of 5,000 square feet. Thanks to our petition and the help of the judiciary, now they have got a proper campus. Infrastructure has been there. To summarize, I think we must have a clear vision of what we want our tribunals to be. Do you want them to be independent? Do you want them to be manned by efficient, competent people? Today, there are so many applicants for appointments as district judges. I am sure that many members of the bar, if they are recruited at 45, 46 into tribunals, and they are guaranteed a service till the age of 62, many members of the bar may choose to become tribal members. They may like a judicial career. Many lawyers prefer a judicial career. They may not want the hustle and bustle and the daily tension of being an advocate, waiting for your cases and so on. Justice Ranganathan, for example, became a tribal member at 35 or 36. Many people I know have become members of tribunals at 40 and served extremely well. So one suggestion we made was in the National Tribunal Commission, don't have the system where a tribunal member is appointed for 3 years or 4 years or 5 years. No lawyer who has finished 15, 20 years in the bar at the age of 45 or 50, who is going to leave your career for a 5-year appointment, leaving all your practice? See, all of us have struggled at the bar. By the time we get our cases, we are 35, 36. When we start getting clients, when we have our own juniors and so on, it takes at least 10 to 12 years. Now, at the age of 40, 45, if I am going to go to the tribunal, I know that I am taking a jump, I am going across to a new kind of career, and I'll be a tribunal member with the possibility of becoming a High Court judge. I've got at least 17 years of government service there. Today's salaries are very good. If housing is provided, if infrastructure is provided, I'm sure that many brilliant young lawyers will take up the path of a tribunal member and will partly become judges. There is also a resolution saying that tribunal members are to be taken as part of the district judges quota for being appointed to High Court judges. Now it's 60-40 or 66-33. So amongst the district judges quota, tribunal members also should be given a chance. So we suggested that create a National Tribunals Commission. Have a tribunal service like in the UK, where young lawyers write entrance exams, are interviewed like district judges, and they become members of tribunals. Similarly, those who are chartered accountants who join the tax tribunals, they can also be selected in the same way. The urgent need of the hour, according to me, is first, tribunals should not be a place where only they are appointed for 4 to 5 years. We have noted that the good people don't come. It's only retired people or people about to retire are attracted, because in normal service they get the age of 60, here they get the age of 62. So at the age of 58, 59, you just opt for a retired post. Or in tribunals where it is 65, you will try to get 2-3 years of service. But we find that the best possible talent is not attracted by this particular system. The second major difficulty here is housing. Most of the tribunals are unfortunately situated only in Delhi. And in the present rules, housing is a major problem. I know many cases where good people, good judges have declined the chance of joining the tribunal and giving judicial service because of the sheer lack of proper housing. So, as part of our goal for tribunal or vision for tribunals, we have to address two fronts. One is the infrastructure and housing service conditions of tribal members, and the other is we have to recruit them at a very, very early age. In the present system, I don't think that if the present system continues, then we are really missing a golden opportunity of having a system of specialized tribunals delivering quick justice to the common citizen, to industries, and so on. One other thing I would suggest, which I must congratulate the government for taking an important step. They have found that certain tribunals are not working, they have sent them back to the judiciary. For example, the Intellectual Property Appellate Board has been abolished. So now patent trademark cases will be heard by the district courts or the high courts as in the past. This, I think, is a very welcome move. They have also shut down 5 other tribunals. When the DRT started, we had 3 DRTs in Tamil Nadu. We had one in Chennai, one in Coimbatore, and I think one in Madurai. Same situation in other places. I always wondered to myself, why create such a DRT? If your problem is banking, if there's a huge backlog of banking cases, create 2 or 3 additional district courts. You see, the advantage of having a part of the district judiciary, there's no question of vacancy. There's always somebody to attend to cases. If one district judge is not there, the additional judge can take charge and dispose of at least urgent applications. Today, we have a very unfortunate system where there is no DRT in Delhi, no DRT in Chandigarh, one DRT in Jaipur. The vacancies are not filled up. What does if a person's property attached in surface, where does he go? Then you have no option but to again invoke Article 226 and the courts are again clogged. So it would be worthwhile examining how many tribunals can be closed and sent back to the traditional civil courts. In my view and my suggestion is that for a start, we can shut down all the DRTs and DRATs and create additional district courts or additional specialized banking courts in the judicial system itself. Give the judge specialized training in banking laws and let there be, just as you got special courts for narcotics cases or special courts for a particular subject, you can have a special banking court in each of these states, and you don't need to have the DRTs at all. You can create, you can close them is one suggestion, just as you close the intellectual property act. You can also examine other such reforms where the tribunals can be shut down or reduced in particular cases. In this context, in the context of debt recovery, the whole argument that tribunals are created because there's a judicial delay was very nicely answered by the Canadian Supreme Court in the case of in re residential tenancies. There was a huge backlog of rent control cases in Canada, and their suggestion was, let's create a tribunal and tribunals will take over these cases, decide them faster. The matter went to the Supreme Court of Canada. They struck it down. They said rent control disputes are litigation between the landlord and tenant. These are private, it's a private list. It's a private dispute. It should not go outside the judicial system. If there are too many rent control cases, answer is to create more courts, not to create tribunals. That was a healthy approach, which I think we should also adopt. And one silver lining was the Supreme Court striking down the National Tax Tribunal Act. See, NCLT, all the company law cases are now with the tribunal. If the entity had been upheld, the National Tax Tribunal, then all the tax cases from all the courts would have gone only to the tribunal. We argue that the high courts today in all tax matters decide substantial questions of law. The legal proposition we made, since all of us are lawyers here, was that deciding a question of law is a core judicial function. It can't be left to the tribunal. Who can decide questions of law? Only judges. And we showed that what are the questions of law which come before tribunals. And we said leaving it to a tribunal consisting of an executive, from a retired bureaucrat and somebody else will be wholly improper. And in the concurring judgment of Justice Nariman, he has summarized, those of the listeners who want to listen, he has very nicely summarized all the important tribunal cases from various courts in Canada, UK, etc. and said that core judicial power can never be taken outside the tribunal. Now, in this background, I think let us hope that we are in the month of January, we are approaching the 75th year of our independence. As it is, we know the arrears in the courts are huge. There's a problem of vacancy, that's a different issue. But it is time that we take complete stock and revitalize our tribunal system, make it completely independent, and let us hope that we have a new dawn as far as the tribunal system is concerned. I thank you all for a patient hearing and wish you all the very best in the coming year. Thank you so much.
Yes, sir. Thank you so much, sir, for having shared with us. I can say within 15-20 minutes, you have given us a complete idea of what is tribunalization in India, sir. Especially how, you broadly categorized it into the judicial, what falls under the judicial, like the MACT, rent, industrial tribunals, etc. Then the quasi-judicial that we have, like the ITAT, CSTAT. Then the constitutional tribunals, like we have the CAT and SAT. We thank you for that, sir, for having given us a gist of it. And also of how the separation of powers, and especially since 2017, how we should have new tribunal rules that is coming up, and the Roger Matthews case. And what we really liked was what the Madras Bar Association has suggested now, especially with the National Tribunal Commission and in their filling up of vacancies, sir. And we really like that you support the tribunal system in a very modernized approach, unlike, it getting filled in the present way. It is very nice because it's also, I think your suggestions would make a promising career for many of the younger lawyers who are coming in today, sir. And especially with the present tribunal, although you said you support it, you do agree that it requires a more effective system, especially with the filling up of vacancies. And that can be by, promising the career at an earlier age as good as a judicial career, instead of giving them a mere tenure of 5 years, and also providing good housing, not that everything should be based in Delhi alone. And also that we have to encourage, and we have to accept that some tribunals are at the same time not necessary, like how the intellectual IPAB was abolished. And, worthwhile about DRT, you gave a very live example of DRTs, for example, can be replaced by district courts. That will give more, vacancies for the lower judiciary, and they also have a judicial career. At the same time, there's also disposal of litigation and justice, dispensation of justice at the same time. I can say an example of the Canada rent control, which, will always stay in our mind, that it has already been tested. This has already been tested at Canada. We can always do that. So we thank you, sir, for this inputs and suggestions. I'm sure, we have to ensure that this is implemented, especially because most of us in the bar do always other of your thing. Thank you so much for imparting your knowledge of things, sir.
Thank you. Thank you. There was a small
Yes, sir.
audio here.
Yes, sir.
Thank you.
But I was audible before this, no, sir, when I spoke?
Yes. Just for a short few seconds.
Yes, sir. So I request our treasurer, Nikhil, to have anything more that you would like to share, sir, in any suggestions like this. This is really nice, a different outlook. We still have time and we are eager to hear, sir, if you have anything more.
No, if there's some questions, no, what happened was I just summarized the various tribunals which are coming, because see, the point is the main point now is vacancies and infrastructure.
Yes, sir.
Like my friends from the Armed Forces Tribunal practice there, they say that in many cases there are no benches. Like you take the Railway Claims Tribunal, there are only 3 or 4 judicial members and 5-10 technical members out of the 20. In many cases, 50-60% vacancies are pending. So you have a tribunal and there is no relief.
Yes,
and
sir.
in many cases, the Act has said the civil courts have no jurisdiction. So you have taken away the civil court jurisdiction, but there is no tribunal. NCLT was also the same problem. So I thought that as a general rule, if it's a list between 2 private parties, as a general rule, let's avoid tribunals, whether it's a DRT or IPAB.
I had a question,
Yeah.
so with respect to that, in fact, you had said that if it's a list between 2 individuals, perhaps tribunes are not needed. But what is your view with respect to mediation and arbitration in respect, between lists, between parties?
Yeah,
and should they be structured in such a manner that they form a parallel system?
Now, two things. First of all,
And you've been in fact involved in mediation at various.
I
You were the general
I,
secretary for the mediation.
for a short while I was joint secretary. Of course, my
Yes, so
friend
you have
Sriram.
first-hand knowledge in terms of how it works.
Yes. As far as mediation is concerned, it is on a different branch at all. Mediation is a kind of way to settle disputes, particularly family disputes, company disputes, and so on. Because as somebody said that there are more than two sides to a story, and having done some mediations myself, I found that very often you can generate solutions which can't be done through a general list. In a court, either you win or lose, you're a winner or a loser, and then you go on appeal. At least in mediation, we're able to sort out a lot of issues, especially in some partition suits and so on. That's a different thing. That's also within the judiciary. There are also private mediations which go on, and that I'm not sure whether that's picked up so much in India, but I'm told in the US and UK, private mediation is a big way of settling disputes. As far as arbitration is concerned, again, the Arbitration and Conciliation Act is there, which has arbitrations. There, the unfortunate part is our institutional arbitrations have not picked up. We still have ad hoc arbitration, though we keep on saying we should have institutional arbitrations. That's one way arbitrations can pick up. But on the issue of tribunals, what my view was that if you go to there was no time, but if you take the UK Tribunals Act of 2002, which I argued extensively before the Madras High Court, there's upper tier tribunals and lower tier tribunals, the two structures of tribunals. So there's a tribunal and there's an intra-tribunal appeal, and it goes on. It is completely independent. It is under the law ministry. Now, right from Chandrakumar's case, they said that, look, let all the tribunals come under the law ministry. Here, what happens very often, the tribunals don't have infrastructure. See, many senior judges, they join there. At least you must give them the basic comforts of a good housing, good car, and so on and so forth. Like if you have an IPAB which comes on camp in Delhi, they don't have place to work at all. So they have to work at Tamil Nadu House or some other private place. So one is that part. Secondly, once it goes to the National Tribunals Commission, we said, look, as a first step, let it go to the law ministry. That's a Chandrakumar, it's not your choice. It's a judgment of 7 judges. It has to be implemented. But an affidavit was filed before the Supreme Court saying that, no, we don't want to transfer them to the... If you go to the Ministry of Science and Technology, IPAB is one paragraph in the ministry report. See, because tribunal has to be independent. You have to have independent people completely. And even CAT and SAT, see, in many cases, SAT has been closed down in Tamil Nadu. In many cases, they shut down the tribunal. What is the point in having CAT and not having vacancies? Now, if you have these tribunals and fill it up, there's a huge amount of work that is involved. And my only concern was, if you have, as Aristotle rightly put it, for younger members of the bar, just imagine if all the vacancies are filled up, if you have consumer courts throughout the country, can you imagine the amount of appointments that can be made? Lawyers can become members.
But sir, are they looking at the younger members? Because, there are a lot of, in fact, PILs also, which are pending in the Supreme Court with respect to filling up vacancies in various tribunals. And most often, even working for the governments in different capacities, you realize that a lot of times, they have advertisements which are left unanswered because the kind of qualification that they're looking for, they're not enough in those areas. So what is the quality that they're looking for in terms of law?
I really don't know, because in the Roger Matthew case, I was also amicus, and with the help of Vidhi Center for Legal Policy, we gave a complete report. Now, for example, even in the latest amendment, which is pending challenge, they said an advocate must be at least 50 years old. So we tried to say that if it's 50, suppose Aristotle is now say 52 and he has finished 25 years of practice. So he looks 35, but I'm just saying suppose he's 52. Yes. It's very unlikely he's going to leave his practice and go on, because what happens after 5 years? When you come back, you have no client. Where do you come? And it's an unfortunate part that very few people have been given extensions. They say that we'll give extensions, but it does not happen. So then what happens is the person who leaves the bar takes a great risk, which is not proper. And what we said was, the advertisements for members, they come in some newspaper which nobody knows. What we had suggested was, just as you know that there is an exam, the entrance exam for the civil service on a particular date, I said, look, let's say that every year, the vacancies, you have an entrance exam for tribunal members on 1st of May. Announce the syllabus in advance, like for the CLAT exams. You have an exam, same thing we recommended for district judges also, 25% on All India quota. We said that you have on a particular day the exam, so people know, like Diksha Rai knows, I want to be a tribunal member. I'm going to prepare for the exam for 2022 or 2023. And I'm fully prepared that if I'm selected, I will be a member and I will retire at the age of 62 as a president, vice president tribunal. Maybe if I'm lucky, I may also become a high court judge and serve for 4 or 5 years as a high court. So he said, have a permanent system where this is an ongoing process, nothing ad hoc. Suddenly there are 9 vacancies, nobody's there, then some PIL is filed, then fill up the vacancy in 2 months, some announcement is made. This then it doesn't augur well for the system. Once we know that it's a smooth, well-oiled system, which vacancies are filled up as and when they arise, then there should be no problem at all.
Sir, sir, with that suggestion, no, sir, don't you? I mean, in your personal opinion, think the powers also should be widened about for the tribunals, the jurisdiction and the powers. What is your opinion? The powers and the
No, actually, see, the point is most tribunals are specialized. Like, suppose you're a DRT member, your powers are there to decide a banking dispute. If you're, say, for example, income tax tribunal member, you have adequate powers to this thing. I am personally against giving tribunals power of contempt and so on. I don't think that's the proper thing. That should be only with the judiciary. But the tribunals are there. What I'm saying is, actually, frankly, the law is in place. There's not much of things. The law is correct. In many cases, it is quite adequate. The only thing is, how do we fill up the vacancies? You know, like all the infrastructures they have to only fill up the vacancies and implement what is there. Now we have to only decide, because this is a burning problem, which is see. The point is, we have now this tribunal system for so many years. Income tax appellate tribunal and CSTAT had people who got recruited at 43, 44, 45 and went on to 62. In my personal opinion, having worked in these tribunals, IT-80 and CSTAT was a good success story. There was a lot of good disposal of cases. You had very good, I mean, you had full law reports where you could see the quality of the judgments also. Now, if you join the NCLT and you are there for 5 years, what kind of a contribution? You will not have adequate time to make a contribution at all.
I have one more question, sir. Sorry, because you're on this. Do you think the appeal system of these tribunals has worked effectively? Because, you know, a lot of these tribunals, they have appeals to Supreme Court also. So how does that work? Because that leads to a lot of backlogs and, you know, there are a lot of pending matters. Does that topic also need addressing?
Yes, you're right. In fact, in L. Chandrakumar, they addressed that, because if you remember the old Administrative Tribunals Act, everything came directly to Supreme Court. And in the early 80s, when I was not coming often there, very rarely I came, all my colleagues said there used to be a huge backlog of cases in the Supreme Court on service matters. Then Chandrakumar said that against the order of any CAT or SAT, it will go to a division bench of the High Court and then go to Supreme Court. That really filtered off matter in Supreme Court. Now, what we found in our research was, wherever the chairperson of the tribunal is a retired Supreme Court judge or a chief justice, then appeal is provided to the Supreme Court, typically speaking. In excise also, in classification valuation, appeal goes to Supreme Court. The Supreme Court itself has said that please stop this, because you're unnecessarily bringing matters to the Supreme Court. Let it go first to the High Court. There itself, 90% cases won't come up. Ultimately, from income tax tribunal, if you see the number of cases which go to the High Court and then go to Supreme Court, there's a huge filtration at the High Court level. Cases get over there itself. See, then there is and then what's the point in having a system where all cases below 2 crores you withdraw the appeal because you can't handle the volume? Unfortunately, that's a part. So, to answer your question, the appellate system should be only to the High Courts on a question of law, not directly to Supreme Court. And from High Court under Article 136, or there could be another the statute can provide for a further appeal to Supreme Court on limited grounds or on substantial questions of law, whatever.
Sir, any suggestions for housing, sir? You did address on the early age recruitment and filling up with a long judicial career. At the same time, any suggestions for housing, sir? Because most of it is...
I actually, when we appeared in this case and we discussed with various people, one of the biggest problems was proper housing.
Yes, sir.
And in fact, now that we are on this thing, I will mention that one retired Supreme Court judge was appointed the chairperson of a tribunal. I will not take the names.
Yes, sir.
And he had no housing for almost 9 months. He was living with his brother-in-law, who was a very senior civil servant. So, and then finally he got accommodation in Mutiba. Now, what I'm saying is, if you know that there are 15 tribunals in Delhi, and let's say they have 45 members, then you at least make sure that there are 45 houses in New Motibaga, wherever housing is provided in Noida, whichever part of the thing. Infrastructure is provided first. Now, one point which we saw in the rules was they get housing allowance, which is available to a Group A officer. It's about 50,000 a month or something, which is not adequate. Now, the Supreme Court has said that they should be provided a housing allowance of 1,25,000, which I think the government is accepting. So you are a person in Delhi. I don't know if the person can get adequate housing for Delhi for 1,25,000. Maybe he can get a decent accommodation for that particular person. But why? See, my point is, why should a retired judge? See, one thing is there. If you're making tribunals where retired people are going to be appointed, particularly where the presiding officer or the vice president is a retired judge,
Yes.
then he must get the similar term which he was used to. If having served as a judge, if I'm not, and just imagine if you're a retired judge, it doesn't look very nice. You have to keep hunting for a house and sign a rental agreement with a landlord and this. So that's not. But whereas if I know that you're going to be a vice president or president of a tribunal and you've got a designated house, this house is meant for the, like we know that X number of bungalows are for Supreme Court judges, High Court judges. The housing is taken care of. So like that, if you do it, it'll make much sense, because one of the biggest problem which members said was, if you're posted to say Bangalore or posted to Hyderabad, then for a tribal member to start hunting for houses is very, very embarrassing. He has to go and discuss with the landlord and bargain for the rent. Then again, they will give a furniture allowance. Then you have to then furniture it yourself. So if the housing is taken care of, that will be a huge attraction for
With
many, many
respect to
good
that,
people.
there's one more query coming from a colleague. They want to know, what about judicial appointments and designation? Why are the tribunal members not considered for those, or people who are practicing in the tribunals not considered for designations from various courts, etc.?
Actually, this is a very, very sensitive topic for many, many years. When I was a junior in the Madras Bar, many tribal members became High Court judges. We had, of course, we had great people like Justice Ranganathan. We had T.N.C. Rangarajan, who went to the Hyderabad High Court. We had, I think, one Maruti, who became an Andhra Pradesh High Court judge, so on. I am told that one practical problem is this. Suppose you're a lawyer from Madras. I'm giving a practical problem, and you have been selected to the Income Tax Appellate Tribunal. Now you get posted in Bombay, Delhi, Calcutta. Like I know my friends who are at the bar with me, they got posted in Calcutta for 5 years, then Delhi, they went here. Now, say after 15 years, when you're a senior tribunal member or a vice president or something, you're posted in Bombay. Now the practical problem was, the Bombay High Court says he's not a member of the Bombay bar, so how can we appoint him here? The Madras Bar says he has left the Madras Bar, he's no longer part of the Madras Bar. So in practice, you're neither a Madras man nor you're a Bombay man, you're some kind of a midway thing, and then you don't get appointed. Whereas according to me, one rule can be, if I'm from the Madras Bar and if I become a tribal member, I should be considered as part of the Madras District Judges quota for elevation to the High Court. My friend Justice Ishwar, he's from Madras, practiced in Delhi. He was a tribal member in Calcutta, then became president of the ITA. And he was selected as became a Delhi High Court judge, retired. But after him, before him also, for many years, there's been no member of the tribunal who has become a High Court judge. And again, is a very big incentive, because I know recently some tribunal members who passed away, they told me that when they got selected, one of the incentives was that they'll be considered for judicial appointments. And after they got selected, then they said, sorry, we can't. Very unfortunate. I know a member who was in Madras, he was originally from Kerala. He could not be considered either in Madras or in Kerala. Judicial members spent 12 years or 11 years as an excellent judicial member. And at least on the tax side, these people can be in the tax bench.
So we have another query, sir. It's the member is requesting that, and I mean requesting as in he wants to honestly know that in your personal opinion, what are the other tribunals that may require to be abolished as on date?
Actually, it's a good question. We can take a step-by-step case. I think we can, for example, abolish the DRT I've already mentioned. We can definitely get rid of the DRT. Then we'll have to seriously think about, say, for example, the competition appellate tribunal. Why can't that go to the court? Because basically it's a list between two private. You say one company has got an anti-competitive agreement, or one company's got this. That can also go. So DRT, for us straight away, I can say DRT can go. Other possible thing is the Armed Forces Tribunal, where the Jawan wants to claim pension. Because see, in AFT, my colleagues who are in the AFT, there were 9,000 cases of armed forces pending throughout the country when the AFT was formed. And the thing was to cure the arrears. Now, because of vacancy, there are 17,000 cases pending in the tribunal. High Court has a better position. So why should, say, for example, now what happens is, if a Jawan in Tamil Nadu doesn't have an AFT, where does he go? So that's also can be a thing. But one simple suggestion is straight away take away the DRTs, go back. And again, as far as DRT is concerned, after IBC and SURFACE, the importance of DRT also is lost because of banking. Nobody is going for a bank suit to recover money. You straight away file an IBC petition and go ahead. And according to me personally, as far as NCLT is concerned, I would suggest keep the IBC in NCLT. For me, better that NCLT goes back to the High Court, but now that NCLT is there, keep only IBC cases in NCLT. All the operation mismanagement cases, company law cases, apart from insolvency, can go back to the High Courts. Today, my colleagues tell me that because of so much of pressure of IBC matters, there is no time to hear old company cases.
So with respect to that, there's another query on the line that we're discussing now, that judicial delays was one of the reasons to shift to jurisdiction from high courts to tribunals. Now tribunals are plagued with the same problem. How do we come out of the vicious circle?
See, one thing is filling up vacancies. And then again, as you rightly put it, I mean, as all of you understood, if you have really competent people, specialized people in the tribunal, it will make a huge difference. Like in income tax, why it worked was, generally people who applied were lawyers practicing on the income tax side, or there were people having some good civil practice but who took part of the career. The technical members were chartered accountants or were income tax commissioners. So there was a huge amount of expertise in that, like just Ishwar, they were all practicing on the income tax side. Justice Ranganathan, he was the standing counsel for income tax department. These all persons became tribunal members. So there was an element of specialization. Take intellectual property. Suppose the tribunal was there, then try to select people from the IP bar.
So your answer would be there for quality and specialization, is it?
No, for the short term, fill up the vacancies.
Yes.
And see, unless this 5-year term is concerned, it is going to be a permanent problem in attracting good people. I mean, I'm asking all of you here, how many of you will leave your bar at the age of 50 for a 4-year appointment?
Sir, with regard to...
Not even at the age of 45, sir.
No, even at the age of...
or even at the age of 40, where we are. I mean, some of us.
Because of uncertainty, see, because you have built up practice, you got a chamber, you got junior, now you leave everything and you're not sure. And see, at least it's a tradition that a person of 5 is automatically reappointed, that also is not there. That's a huge problem.
So with regard to vacancies, what we are talking is filling of vacancies, and as suggested, another member wants to know that, are you suggesting that every member, including the chairman, has to continue in the same mode of recruitment, or you're giving a breakaway with the chairman and the president, or will it continue with retired people? The question is whether, what mode. I mean, they appreciate the approach of filling up the vacancy through the judiciary, sir, as in you suggested. But what they want to know is what would be the role of the retired judicial officers thereafter. If we are continuing with this mode of recruitment, then what would be the role of the retired officials?
You see, the present method of selection is for income tax tribunals. Ever since I was a junior from 1980, the chairperson was a senior Supreme Court judge, and the president of the tribunal and a member law secretary would be there, and they were the selection committee. Even now, also the selection committee, which has been approved, which has been held by Roger Matthew and which has now been there. They are in, let's say, a committee of 5 is there. Then there are 2 Supreme Court judges, 2 civil servants. I mean, the judges are in a majority. There's 2 Supreme Court judges, chairman of the tribunal, and 2 bureaucrats. That's the selection committee. My personal suggestion is, as it is, Supreme Court judges are highly overburdened. They've got so much of pressure of judicial work. Now, to ask them to go from place to place, do the selections, because see, suppose they're going to recruit candidates, they'll at least go to the biodata of the candidate, spend 20-30 minutes interviewing candidates. So one suggestion was, if there's a selection committee consisting of retired judges who can be on a panel. I was suggesting, like UPSC, have a panel of 10 retired Supreme Court judges or High Court judges, and at any point of time you can request 2 or 3 of them to come and select the candidates for the interview. That's one method which we can do, and that will be taken care of with the National Tribunals Commission will take a large part. The present system is that the other reason why it has got stuck now is the Act says that the committee will recommend 2 people or 3 people per vacancy, and the government will select one. What we are arguing is, once the selection committee headed by a Supreme Court judge and consisting of civil servants, once that selection committee has selected Mr. Aristotle and say Mrs. Rai, then it should not be left to the government to pick and choose. They can't say that you appoint, give me 3 panels and I will pick and choose one. We say that harms judicial independence. Is our stand. That's pending in the Supreme Court.
Sir, in lines of that, there's another question on. I'm reading from the tube. I mean, we are live on YouTube, so the chat. It says, why not senior members of the bar be appointed as member in tribunals? Probably like how in High Court, the senior members of practicing are chosen to the bench. Why not that is followed? Why not senior members of the bar be appointed directly as members of tribunals?
But also just one, I think to add to that, just a thought has occurred to us. Perhaps even in terms of that, should the bar also prepare itself to, perhaps have ad hoc terms and, just think of it as a service and
provide a list.
Not wait for a 20 years career and be prepared to do a 4 or a 5-year career? Should we perhaps have a balance, something like that? I'm playing the devil's advocate here.
In some context, some of us have made a recommendation in the context of judiciary that let us say senior members of the bar, let's say, suppose I'm specializing in taxation, you're specializing in criminal law, then I agree to serve for 3 years in the judiciary or 2 years in the judiciary, and I am appointed, let's say, in Karnataka High Court as a judge, so that I help in disposal of tax cases in my area of specialty. To preserve independence, we also make it clear that I will not appear in the Karnataka High Court and I will not take any case from Karnataka for 5 years or at plan. So that was the system, but it was not very popular. I made the suggestion to some judges also, but it was not. But now that you mentioned, it's a good idea to select. Suppose it's a 3-year term, so a person can be a trial member for 3 years and come back. But instead of that, I don't know what. That's a possibility. You can definitely think as thinking out of the box. Why have 5 years? Let a senior member agree to do public service by functioning for 3 years. Let him leave his practice, do 3 years service in a tribunal and come back. That's definitely a worthwhile idea.
Thank you, sir. It was very enlightening to all of us.
Thank you, and thanks to all the audience for taking the time to ask so many questions.
We have Nikhil with us, sir, the treasurer, who will formally deliver the vote of thanks for us. Please. Nikhil, please.
It gives me immense pleasure to deliver the vote of thanks for this event. On behalf of Executive Committee of Supreme Court Advocates on Recordization, I would like to thank our guest, Shri Arvind Datar, Senior Advocate, who honored this lecture with his thoughts on the topic tribunalization in India. I would also like to thank our President, Shri Shivaji Yadav, our Vice President, Manoj Mishra ji, our Secretary, Aristotle Joseph, our Joint Secretary, Diksha Rai, our Joint Treasurer, Atulesh Kumar, Dr. Hamorim Rani, and other member executive of our EC. We are very thankful to all the members who have shown interest in attending these sessions and taken our time to connect virtually. This further encourages us and motivates us to continue to hold such sessions and provide a platform for such exchange of knowledge by eminent speakers. We once again thank Arvind Datar sir and other attendees who have spared their time on a Saturday evening and graced the occasion. We part briefly to rejoin again for the next similar session. Till then, please take care, good health, and stay safe.
Thank you so much.
Thank you for the memorable evening, sir.
Thank you so much. And I look forward to seeing all of you in person as early as possible.
Thank you, sir.
Thank you. God bless.
I'm ending the session. Thank you, sir.
Thank you.